Not that I talk during these things, but
Should be ready to go.
all right. Work session begins. Mr. Byrd.
Thank you, Chairman. Cody Byrd, Planning Director. Gonna start with just gonna start by muting this there. Got it. Gonna start with just kind of a high level overview. Tonight, we're gonna do a work session here beginning at 5:30. The topics on tonight's work session, we're really kind of trying to focus on land uses, land use descriptions, and our land use table as part of our zoning code. As a reminder, the town adopted the comprehensive plan in August. The next step that we're trying to complete and get everything in order is the land use code. Our land use code is a broad scope of definitions, requirements, zoning, subdivision process, all of our use standards and use limitations. The overall document for our land use code provides the regulatory framework that enacts the policies that we adopted in the comprehensive plan. It's very broad in its entirety. And what we're trying to do in these work sessions is kind of break it out into smaller pieces that are more understandable. At the last meeting, we talked high level land use table. We focused on kind of some of the simpler type of land uses like single family homes and where are those permitted, or retail business and where can those be located. And tonight we wanted to a little bit more specifically provide time for questions and answers and dialogue around some of the more complicated and legal based land uses. So that's what we anticipate doing tonight. We do have some of our consultants that have been working on this project with the town. We have Mark White and Reese Wilson from White Smith LLC Planning and Law Group. They're subject matter experts on some of these more complicated land use types, and they are providing the legal analysis and helping with drafting all of the land use regulations for our land use code update. So I'm really pleased to have both of them here with us tonight. We have about 45 minutes or 50 minutes for the work session right now. We do have regular business items to conduct at 6:30, and I anticipate that we'll have some follow-up conversation and dialogue about the work session topics after the regular meeting. So that's our pretty high-level overview. Before I invite Mark and Reese up here, I also wanted to address some of the complicated natures of our land use code, and that's sexually oriented businesses or adult uses. Sometimes there's uses that aren't exactly easy or comfortable to discuss, and that's exactly why we put those in our land use code. We've got some social media posts that were made over the weekend with various understandings or misunderstandings of what is required, what the town wants to do, what the town has to do. And so just at a high level, we're all humans and some of these uses can be uncomfortable to talk about. Sexually oriented businesses, town doesn't currently have any applications for any use of that nature. What we're doing is talking about our land use code at a high level so that we can be prepared if one of those land uses comes, and what are the requirements that must be met for a type of a use of that nature in our town of Wellington, what makes sense for our community. So just trying to throw that out there. It's something that we have to talk about. That's why it's in the land use code. That's why we're talking about it tonight. But it's not being driven by any applications or requests. It's just a procedural matter that we need to work through. Any high-level questions? Okay, then I know that all of our commissioners are enjoying some dinner tonight, and staff will as well. So with any further ado, continue your meal, but we'd like to start with a presentation from Reese with White and Smith LLC.
This is what's currently in there.
So we're now sharing the PowerPoint presentation, so it's available online as well. This is the same presentation that was included in the packet.
Hello, y'all. My name is Reese Wilson with White & Smith. I've been working with staff for probably about 6 months with different parts of this code, and we're going to talk about use regulations. We're going to talk about some specific uses that need a little bit more detailing. Mark's going to come help talk a little bit more about those certain uses that Cody just mentioned. We're going to get a little bit into parking and possibly some other topics, but we're just going to power through and let me know if you have any questions. You need me to stop. You need me to do anything else. So Cody, could you go to the next slide for me? So yeah, so today how we have it set up is we're going to do a review of kind of where we left off, talk a little bit about the use table, our approach, some best practices. We're going to go into that deep dive of those specific uses. That's when Mark will jump in, get to parking a little bit, and then hopefully we can talk about our next steps. Next slide for me, Cody, please. All right, so y'all have already seen the use table. We're still going to be working on it with staff and more input coming, but kind of our approach with the use table is consolidating uses that are existing, modernizing them to fit what's currently going on in Colorado and in the nation. We originally did this with like land use categories, putting in, risks of retail, but per your advice, we've gone with the alphabetical arrangement to simplify it, make it easier for everybody to understand. We're defining each use. So in that table, when it's all said and done, it's going to be very easy to understand what a use is. So a retail use is yada, yada, yada. This is what this use is. And that's going to take a little bit more time as we talk with staff and keep working with y'all to get the right definition for each use. Also in that use table, we're going to provide, or just what we're going to get into is use regulations. So these are additional regulations that coincide with the use. So how we typically do this is we'll put on the side of the use table, we'll have another column that says use specific standards or use regulations that are applicable. So like a retail store, they'll have additional regulations to mitigate for, adverse impacts. They also show like the allowance, to cut out a little bit, it'll show some of the allowances, what it would trigger a conditional use permit. And additionally, with those regulations comes, or why we do it, is to make sure that we right size these uses to the corresponding zoning district. We understand that all uses aren't going to be applicable in, certain zoning districts. Some uses are more appropriate than others, and this is a way in which we go about doing that. Also, another reason why we have use regulations is sometimes when we're doing our work, council, board staff, they get frequent requests for variances or conditions on certain site plan applications. So, if you notice that there's a certain setback that keeps coming up for a particular use, and you keep elongating the process, we provide some relief for that, and it just simplifies everything going forward. And those are usually not typical variance requests that require legal hardships. Next slide for me, Cody. All right, so we're going to talk about our approach to kind of how we do what we do when it comes to uses and use regulations. So first thing we do is we look at the town's plan, which is the comprehensive plan. We look at what's most important, what y'all value the most, making sure that everything complies with the vision that's been adopted by this town. And then we look at the existing regulations. We look at the current uses. We look at if there are any additional regulations, how we could work with those. When we start putting on our thinking hats, we start looking at, ways in which we can improve or streamline or make things better and easier for y'all. The second thing we do is we like to hear input. We like to, talk to staff. We like to talk to the community. We like to talk to y'all. The people who, make these decisions, we need their input. The people who are most affected by these, uses in certain zoning districts, we need their input. And so we like to take that into account as we work through our process. Third step we usually do is it's a very helpful tool that gets us to the drafting stage. It's like a peer comparison, identification of jurisdictions in the area. They could share the same geographic size, population, region, whatever. And then just seeing where your jurisdiction kind of meshes with others, so that's a very helpful tool for us while we're doing our use regulations and our drafting. And then the fourth stage is the drafting stage. So after we get done talking to y'all, the staff, us doing our research, and just examining and seeing what's best for all y'all, that's when we prepare the draft. And then we give the draft to staff, and then gets reviewed, and offer more feedback, and we get it all together, and then we present it and get it ready for the entire code. So the next slide for me. Thank you, sir. So we're going to talk a little bit more about the best practices. There's just some common things that you see with use regulations or use standards. So usually you'll see, like, if you'll go into use regulations, you'll see spacing or distancing requirements. So we'll talk a little bit about each one in depth as we go through. Size requirements, operational requirements, special buffering and screening, and then certain things you can do with outdoor storage and display areas. Go ahead for me, Cody. Thank you. So the first one we're going to look at is the spacing requirement. And so what's pretty typical, in most modern codes when it comes to use regulations are spacing requirements. So I put an example of, any building can't greater than 3 stories shall be located 500 feet from a residential zoning district. And so this image right here kind of illustrates what we're talking about. And the reason why use regulations like these exist is because it limits the use by providing specific locational requirements. And it makes sure that you don't have, that these uses are, the residential zoning districts are set intact, are intact, and they're not as affected as would there be if there were no spacing requirement. It kind of be unreasonable to have a 5-story building right next to a residential district. I would imagine that would cause some problems. It wouldn't flow with the neighborhood's compatibility. This is a way that we go about accounting for that. Next slide. So this is kind of for carrying on with more of the best practices in size, but this also could be a spacing issue as well. And so the size for, different types of uses and where they're at, just to build more upon compatibility of the uses in the built landscape. So in this example, I have, in a downtown district, no retail store shall exceed 5,000 square feet building area. So anything that's above 5,000 square feet, as a retail store wouldn't be allowed. Or you can tack on that triggers a conditional use permit. And so the reason kind of why we have this particular regulation is that we're trying to right size the building size to a specific zoning district. We're really trying to calibrate it to a point to where impacts are not as noticeable as in this picture. This is from my hometown. And I would imagine if you own that home, you wouldn't be too happy with this ginormous office, high-rise condo thing right in your backyard. So this is kind of the reason why we have, size requirements. If you put a stipulation that says, hey, an office in this area abutting this property can't be more than 10,000 square feet, that's a lot more feasible. That's a lot more reasonable for that area as opposed to this 14-story whatever building it is next to this $1 million home. Next slide for me, Cody. Another common best practice is operational requirements. So these are like your occupancy levels of what can happen, how many people you can have in your type of establishment or type of event, the hours of operation, event duration, all that kind of thing, all those kinds of things. So this example is the car wash now be open for business between the hours of 10 p.m. and 7 a.m. And so really the reason is to make sure that for this type of regulation is to reduce noise, in traffic in certain areas, because certain car washes, depending on the scheme and the type of machinery that they use, can increase, dust, can increase traffic. It can increase a lot of noise. I know in my past experience as a municipal planner, the city that I worked for, we had a lot of issues with car washes and how they impacted neighboring residential areas. And so this is just a typical standard you would kind of see with a use kind of associated with this to account for these types of developments. So that's the next slide. Thank you, sir. So special screening and buffering is another common best practice. This one's a little bit lengthy, but essentially you're basically providing screening areas. You're providing a screening wall or landscaping wall to provide buffering from unsightly development in certain areas of your zoning, of different zoning districts. And so this picture on the top left is where I went to college in this town, and I used to get my car serviced there all the time. But I remember it just being so unsightly, just seeing cars all everywhere. You're on a public road and you're seeing everything that's going on inside the shop. And it's just, half the time it just looked like an abandoned car spot. And one of these regulations right here kind of account for cleaning up the site. We're not telling them what they can do inside their site. What we're doing is we're making the area look a little bit better, a little bit more upkept, instead of seeing, abandoned cars or cars that are, inoperable and all that. And then the bottom picture is something that we've worked with in a different jurisdiction in Kansas. That's kind of a landscape buffer for like where the loading docks of big trucks go. And that's adjacent to a residential district. And so that retaining wall with the landscaping and the fence, that all kind of adds it to a transitional effect between that use and a residential area. So next slide for me. This is another common best practice. This one's also from my hometown. And outdoor storage and display, there's all types of regulations that can apply for any type of use, or specifically for outdoor storage use. And really, for this example, I just have it simple. No outdoor display is allowed for a pawn shop. And the reason why is it goes kind of back to the last point we were talking about with unsightly development. It's a nuisance. It can be problematic for the landowner, the property owner. There's theft. I know I used to frequent this place a lot growing up, and there used to be numerous thefts because people just come and take stuff. It's unsightly because it's on the curb. I mean, if you're an establishment and you want to protect you want to protect your property, you want to protect your image, I think, having some strong standards that kind of prevent this from occurring can be for the betterment of the code. And like I said, this type of regulation is just to reduce clutter and to prevent unsightly development. Y'all have any questions so far? All right, so this is going to be the segue point for Mr. Mark White, and he'll kind of get us going in a little bit more of those more detailed uses. I appreciate y'all's time.
Teresa.
You want my computer?
That's all right.
Okay.
Thank you. Next slide, please. Reese just gave you some background on the kinds of standards we look at when we get into what we usually call supplemental use regulations and start adding standards that mitigate some of the issues the town has had with certain types of uses in the past. That's one of the reasons why we have that. He also mentioned there's other reasons. 3 of the ones in this slide have federal or special protections under federal law. And we need to recognize those when we process those uses. One is telecommunications facilities, things like everything from cell towers to some of the more modern 5G and distributed antenna systems have protections under federal law that say that you have to have findings of fact and conclusions of law. When you process these things, there's what they call a shot clock. You can't take forever to make a decision. And the Spectrum Act, which is passed about 5 years ago, I think now, says that we can't regulate certain expansions of these things up to a certain level. There's a lot of detail in these regulations. We just need to make sure that what goes into the zoning code protects you when you process them. The second one that enjoys federal protection under federal law is religious land uses. There's over 20 years ago, the Religious Land Use and Institutionalized Persons Act, called RLUIPA, was passed that put limits on how local governments can specifically regulate things like churches and mosques and synagogues and other types of land uses through zoning. We cannot, through conditional use processes or other things, attach things that substantially burden the exercise of religion. That's a very open-ended standard. It's one that defies a specific set of standards in the zoning ordinance. And one of the more specific ones is we cannot treat religious land uses different than other types of assemblies or institutions. So somebody's meeting to pray and worship, that's no different than somebody meeting to discuss Einstein's theory of relativity or watch a boxing match or whatever other type of assembly they're engaging in. We cannot treat religious land uses on less than equal terms to those types of land uses. So we need to make sure there's parity in the zoning, that list of uses that Reese showed you earlier in the slide. But any standards we apply to religious land uses, we also have to apply to other assembly uses. Any accommodations or concessions we make towards other assemblies, we have to make towards religious land uses. We have to treat them equally. So it's important under federal law that we're careful about how we regulate those through zoning. The last one, another use that's a lightning rod in every community I've worked in is what we call sexually oriented businesses or adult entertainment facilities. Those, as with religious, I mean, you're all aware that, the First Amendment protects the exercise of religion. It also protects speech and expression. What happens in adult entertainment facilities is considered by the federal courts, whether we agree with it or not. It's considered a form of expression. So there's a very complicated body of law that's arisen. I have a treatise just on the law of zoning adult uses that's literally 3 inches thick, that says what you can do and can't do. But in a nutshell, we have to have sufficient land zoned for uses like this. They have to be zoned by right. We can't attach discretionary processes that are either one, subject to 20 different interpretations when it gets to the Board of Trustees or whoever the decision-making agency ends up being. And there has to be a reasonable and short period of time for issuing the permit. Those are requirements that have been passed down by the United States Supreme Court. They apply to every state, every city, every county, every town in the United States of America. What we can do is we can limit religious, or not religious, as we can limit those uses to certain districts. Right now, it's your industrial districts. We can set spacing requirements. Reese talked to you about that, so that they're not located within a given distance from a residence or a school or a religious land use or other what we call sensitive land uses, where that's just not going to be a good neighbor for those. But once you apply all those standards, there has to be a reasonable amount of land left over. What is that amount of land? Well, that's why I always say I'd love to be a federal judge someday, because they won't tell you. They'll tell you after the lawsuit is over whether you did your job or not. When I've studied this in the past for other communities, usually if it's 5% or less, it's a big issue. If it's 5 to 10%, it's a gray area. If it's more than 10%, you're probably good. But again, judges look at that on a case-by-case basis. So we need to be careful again with how we set those up, because that's a federal requirement. And as Cody mentioned earlier, this was brought up in this context, not because there's an application. It's not because we're wanting to invite things like this into our community. It's because we want to be prepared if you had an application for this. We want to make sure we are on top of this issue. We're being proactive, and that those uses are allowed only in locations that are appropriate for the town of Wellington. But we have standards that aren't going to get the town into a lawsuit that it can't win and could result in a lot of financial exposure and that sort of thing. It's a balancing act, and it's tough. So anyway, those are the three land uses that have protections under federal law, and that's why we've carved those out. Telecommunications and adult businesses would have their own section of the code, I would imagine. Religious land uses could either just be treated and put in the same categories where we put things like convention centers, other institutional and other assembly type uses. Where those are allowed by right, we have to allow the churches and religious land uses by right, and et cetera. So we need to make sure that that's carved out. And we could also have special standards for assembly uses that deal with things like parking, that deal with transitions from uses like that to residential neighborhoods that might be affected by noise or traffic or that sort of thing. So those are those uses. Another use deals with, this is a growing town. You're going to have, your demographic profile is going to change in the next 20 years as you grow. You're going to have people, younger families that need housing and so forth. And so we have, and it's recognizing your current ordinance, we've kind of consolidated and flattened the terminology a bit, but this is accessory dwelling units where we would have some standards that allow somebody to take, for example, a garage in their backyard, to retrofit it, add some bedrooms and a kitchen. A family could live there, a family member could live there. A lot of people, as their parents age, that's a good, it's good to have them there. They're close by. They have some semblance of independent living, but they're also close. You could rent it to a young family or something. It provides a type of housing that does not visibly change the density of a neighborhood. Those neighborhoods stay single family. We're not replacing single family dwellings with apartments and things like that. These are usually occur in the backyard. They can occur interior to the unit. So, somebody could carve out a piece of their home, maybe with an extra kitchen and bedroom or something like that. So the visible character of those neighborhoods don't change. They still retain their single family detached character with accessory dwelling units. Plus, those property owners, have more valuable. I mean, it makes their property more economically valuable. They can collect rent. Sometimes that helps them pay their own mortgage. So it helps for the, people who want to stay here in Wellington and hang on to their house. And, it gives them an extra source of income. And we find too, because it's an investment. I mean, my wife and I happen to be building right now in a new urbanist community in the town I live in outside of Kansas City. And, these homes are all on alleys. They replicate the traditional style of building. And some of them have accessory dwellings. They allow those. A lot of them, incidentally, it's like for summer training for the Royals, they'll have players come in. A lot of them rent houses there. It's a neat thing. It gives that property owner extra income and et cetera. It's also an investment. So we didn't do it right now because it's just a lot of extra money. So I know when I bring this up, sometimes people are afraid that, we're going to see all these, every lot's going to have one of these. And, the reality's you may get 10%, 20%, et cetera. And it's a win-win. And we're always looking in our codes for anything that's a win-win for the community, that gets us something that's consistent with your needs for housing, is consistent with your long range land use policies, and a winner for the property owners. That would be a great thing. The other one that's kind of related to this is short-term rentals, as we call STRs, short-term rentals. Your Airbnb, your VRBOs, those sorts of things, which are growing. We see this everywhere. I'm sure you've experienced them here in Wellington. I've seen them everywhere from resort communities where it's obvious to places like the unified Kansas City, Kansas, which is a very poor part of Kansas City, gets a lot of applications for these. People want them for various reasons when they're visiting. Sometimes it's people are comfortable with those as opposed to hotel rooms. Sometimes they're cheaper. And again, like with accessory dwellings, it's an economic return for people who own houses. It's also a concern sometimes for people who live around them because they're instead of their neighbors that they see every day, they're getting more of a transient population moving in that may or may not care as much about what goes on in the neighborhood, especially long-term, as the property owners who live there. There are concerns about noise and activity. Sometimes I know in Kansas City, Kansas, there are complaints about parties and stuff like that. And, you know, the agencies that lease them, you know, they have some standards of their own, to be fair. And to be fair, sometimes that happens anyway. So there's a lot of things communities do with short-term rentals. Sometimes there's a cap on a block by block basis. They only allow 2, 3, 4 of them. You get beyond that, then you have to either get a conditional use permit or it's just a firm cap, something like that, along with operational standards, as Reese mentioned, to make sure that if somebody does this, maybe there's a limit on the number of days per year that they do it. So you don't get somebody who's just becomes sort of an absentee landlord and they buy a house and that's all they use it for. And you know, because that can be an issue. The last one, of course, in Colorado, you know, it's been a big, Colorado was one of the first states, if not the first one to, you know, to legalize recreational marijuana. And those uses have been controversial, as I understand it. Wellington approved allowing these by one vote. It was, so I imagine it was probably a strong debate in the community. My understanding you know, I don't have more details than this, but that if you apply the state regulations of these types of uses, there's really probably one place in the town where you could have one anyway. So these would be recognized, you know, whether it's a dispensary or something else, you know, however it was approved, they would be recognized in the use table, and any additional standards we need to apply, you know, in addition to the state regulations, for example, we would take a look at those as well. So that's your murderer's row of uses that tend to get people upset or arguing or that just need special protection or sometimes a special accommodation in the ordinance to achieve other public policies. So I'm going to turn it back to Reese now, but before I do, any questions about those? Yes, sir.
All right, so in all these here, right here, if I heard you right, you said we have to make sure we got adequate space use area for these
That's the adult businesses specifically.
only.
That's one of the elements of federal law. Now with, that's kind of a moot issue with religious land uses because we have to allow those wherever an assembly is allowed and that sort of thing. Short-term rentals, I don't think we have that obligation. In fact, some communities don't allow them at all. And so I think that would be fine if that's what this community, same with accessory dwellings. If you didn't want to allow them, this is a policy issue that we're bringing forward. Telecommunications, we have to allow those under federal law.
And the sexual oriented businesses.
Correct. We have to allow those somewhere in the town.
Adequate space.
Adequate, yeah, an adequate
Doesn't
amount of
apply to
land.
marijuana though.
Doesn't apply to marijuana, correct.
Okay.
Yep. So, any other questions?
I did have a question. I wasn't sure. A lot of times, I don't know if the town's code is this way now, that an accessory dwelling unit needs to be occupied by a family member. You were indicating, at least in your community, that it could be more of a rental and it doesn't have to be a filial relationship between the people. I don't know if that stands true in our community or not.
I don't recall. Is that a standard now?
No, our current code, Mr. Whitehouse, doesn't actually address any specific standards for accessory dwelling units. They're not explicitly prohibited, but they're not very well addressed in terms of what would be needed to accommodate that type of use. That's one of the reasons why it's on this list, is it's a growing topic of conversation amongst planners to how do you accommodate more a variety of lifestyles for granny flats, mother-in-law suites, that college-age student who you can't get out of the house, giving them some space to be independent. There's a wide variety of circumstances that are coming up in our society today. And the accessory dwelling unit has largely been identified as a way to address those various types of needs.
Yeah, and you mentioned something specific. It's a pretty common standard that if you have one, the owner has to occupy the principal unit. A lot of regulations require that way. Again, you don't get absentee landlords, somebody buying a house, renting the house and then renting the accessory dwelling, and all of a sudden your neighborhood becomes just rental houses. There's one state, I know in North Carolina, the courts ruled that that was unlawful because zoning only deals with use. I think in Utah, which is closer to us than North Carolina, they went in the opposite direction and upheld that because, again, it's a way to protect the value of the neighborhood and avoid having a transient population move in. But that is a common standard, so I'm glad you brought that up.
Okay, thank you very much.
You bet.
Both of you.
Thank you.
And Mark, I was going to throw in there too. I know I've seen a couple of examples for usually more associated with rooming and boarding houses or for boarders or renters, that those types of additional uses do need to be addressing the familial units. I think that in large part, from what I can tell, is changing somewhat to allow more renter options. And I think, as Mark alluded to earlier, that's likely going to be a policy decision on how we structure that for accessory dwelling units, if that's something we want to allow in our code.
Okay, thank you.
Thank you.
Can I make a comment here? Okay, I'm thinking about the industrial park to the north of us that Mr. Piper has. Okay, private streets, private industrial park. So just for future thoughts, if there was a sexually oriented business that wanted to go in there and he says no because it's a private industrial park with private roads, where's the town going to be?
Oh, I'm glad you brought that up. That's a very good point. What federal law does not require is they don't require, that's that guy operating in the market, whoever owns that park, if they don't want that business there, they can say no. And if everybody who leases property decides where we allow it, decides they just don't want to rent it to them, that's not a First Amendment issue. That's just the marketplace operating. The town's only obligation is to make room for them somehow in the zoning ordinance. But people who own the park say, you know, you're zoned properly, but we don't think this would be, just as a manager of the park, we don't think our other tenants would be very happy with you here. They're under no obligation to lease the unit to the adult business. So, you know, that's our only obligation is to make room in the zoning ordinance somehow.
Clarification.
You betcha. Thank you.
Thank you.
It's a question.
Is this my favorite subject coming up next? All right.
All right.
I know, I can't wait.
All right, so we're gonna switch gears a little bit, but the use table, use regulations, this all comes together. Parking is all part of that. It's how we like to, our approach is we like to tag parking ratios to each use. We just don't have like a general broad category, one size fits all approach to parking. The reason kind of why we do that is make sure uses are adequately parked. There isn't a lot of, you know, just, it's not a broad brush type of approach. So I'm just going to ask some general questions. I know parking has been of discussion in previous meetings and previous discussions with staff, the public. What type of uses generate the most parking in Wellington?
Restaurants.
I mean, restaurants and breweries really are the two
Okay.
most common.
Very common.
We have one example, and I'm not gonna throw the businesses out, but there's
Yes.
a brewery and there's 2 or 3 other businesses in the same complex.
Mhm.
And I'm not sure that when that was approved, we knew there was a brewery going in there for sure.
Mhm.
And so consequently, that particular situation always has parking issues when it's busy. There's
Okay.
nothing we can do about it now.
Mhm.
We just have to deal with it.
Mhm.
But is there a way to avoid that down the road?
Mhm. Yeah, so that ties back into, I'll get back to the question over here, but that ties back into use regulations. very common, especially we do a lot of work in Colorado. And one that's always coming up are the microbreweries, the little micro wineries, those types of things that you'll see like on a downtown square or something, or, it's not an actual full scale brewery, but it's those micro ones. And that's what those use regulations get to. We also make sure that the parking regulations fit that use. There's also, like in that case, moving forward, it's a good example for us when we form our parking ratios and things that you would want to see when it comes to parking regulations. You can do shared parking agreements. There's, on off times, there's peak flow times. There's all sorts of ways you can remedy those types of situations. So that's some good insight. We like that. We're going to take note of that, and we'll move forward and hopefully provide something that can prevent something like that from happening in the future. Any other, you had a question or comment?
Oh, I was just thinking that also 4th of July, Halloween, and Christmas parades generate parking issues around here. And so this last Saturday evening, corporate told us at the store to put up signs that say no parade parking. And so we got a lot of middle finger salutes as people drove in and had to leave and pulled back out because they wanted to park in our parking space. And the convenience stores limited the parking too. So those are other times when there's an awful lot of parking issues.
Special event parking?
Yeah.
Yeah, so there's ways to address that. That's also ties back into our use regulations. When we talk about special events, temporary events, permits, there's certain jurisdictions in Colorado, around the nation, that deal with those types of events differently when it comes to parking. Sometimes they offer satellite parking facilities, and they have like a shuttle or a short walk to go to the event or whatnot. I know in my last experience as a municipal planner for a nice sized suburban city outside of Dallas, which is this area right here, this picture right here, they would host a lot of closed off events in the little downtown square to generate a lot of people coming in. And so what the city would do is they would talk with big parking space providers, such as religious land uses. So a lot of the local churches struck an agreement with the city that would offer up parking spaces on, the Saturday, there's an event from noon to 8 o'clock. Well, from noon to 8 o'clock, they would offer up all their parking for the public, and the city would run like a little shuttle, and it's only like, it would take, 10 to 20 people, and it's only like a 2-minute shuttle, and you probably have a 5-minute walk. So those are some types of options that you can do within the code or sometimes outside the code, but there's also other things that we can look at to account for those type of temporary and special events. So any more comments on that question? The other kind of question I got is like, where is parking most problematic? I would imagine you're talking about downtown area and special events. Downtown would probably be a little bit where parking is needed. It's too much of it. It's too little. It's not, walkable. It's all sorts of things. Is that an accurate, assumption that downtown needs a careful study, a careful analysis of the type of parking that's required for certain uses?
Well, I would say that you start talking about parking downtown and you will find that people feel very strongly about this. And I find it really amusing because if you get out of Fort Collins, and they do have some municipal parking, and if you can park 4 blocks from where you're going and you're thinking, I lucked out. Now, if you can't park right in front of where you want to go, apparently there's a parking problem. Like you look down the street a block and a half and there's plenty of parking. So I think it's a perspective thing, really.
That's insightful. Agreed. Okay. All right, then. If there's not any more comments or questions or, or answers to this question, I'll continue forward. We got about 15 minutes. We're going to talk a little bit more about common parking practices, best practices, kind of like how we did use regulations, the spacing and all that stuff. We'll talk a little bit more about common parking practices. So the most, widespread practice is parking minimums. So each land use requires X amount of parking spaces per, X amount of square feet or number of occupants or whatever you have. Additionally, there's maximums, which is a newer approach in the past 10, 15 years that provides, instead of having a required minimum, you have a required maximum parking. So, if you can't park any more than, 5 spaces at 200 square feet for a building. That way you prevent from overparking. You prevent from, wide expanses of parking like you see in this picture. I would imagine, I think this is from like Santa Clara or something, or San Jose, but you don't see a lot of green. You see a lot of pavement. And you see some interesting buildings. And that's kind of what those maximums kind of get towards. There's parking districts. This is an approach that's pretty common, especially in Colorado. A lot of the ski resort towns, a lot of the smaller towns with, identifiable downtown areas that want to keep the character going. They identify it as a parking district, and they have certain ratios and regulations that apply just to that area. Everything outside of that, it's just the standard approach of, a minimum is 1 space for every 500 square feet or whatever. And we've done a lot of work in the Colorado area, and we're probably going to continue to do a lot of work in Colorado, and specifically with parking. And this is a very, very common approach that we see when we develop our parking regulations. Another common parking approach or practice is right sizing. That's basically calibrating each land use with the parking ratio that meets that particular use. And you can even take it to another step, making sure that that use and that ratio for that parking applies to a certain zoning district. So one of our projects that we worked on, it's on the East Coast. We propose to basically go zone by zone or zone by zone. So a retail establishment might have, in a agricultural district, might be 1 to 1,000, 1 space for every 1,000 square feet of building space. In a commercial area, might be 1 parking space for every 500 square feet. Because as you would imagine, in a commercial area, you have retail activity, you probably would want to have more parking, as opposed to, you're out in, an agricultural area, you would probably not tend to have, 1,000 people coming to look at, farm equipment, but you might have 1,000 people going to Target, on a given day or a given time span. So right sizing is kind of a tool that we use when it comes to parking practices. There's also reductions. That's also very common, specifically in downtown areas, finding ways to reduce parking if the developer provides something, or we make incentives, we make trade-offs to make sure that there's not over parking, but there's sufficient parking for everything, for each use that's in that area. So there's a variety of ways that you can go about reductions. But for the interest of time, we'll keep moving forward a little bit. And there's shared parking, like we talked about earlier with that example you provided. That's a simple way to, if you have 2 high activity uses, but they operate at different times of the day, you can strike a joint parking agreement to kind of regulate. It's like, hey, if I have a bar restaurant type establishment, and it's going to generate 50 cars in my parking lot every night, but I have a little office space that runs from 8 to 5, it's only going to generate, 20 parking spaces throughout the day. You can kind of strike up an agreement and say, hey, well, the bar restaurant establishment can use those parking spaces for that office that the office is providing during those hours of when they have peak capacity. So there's different types of ways that you can go about providing ample parking, but not providing over parking. Next slide. And so we talked a little bit earlier about our approach when it comes to use regulations and doing comparisons and analysis. I know y'all probably can't read the text on that screen, but this is an internal Excel sheet that I have where we looked at neighboring jurisdictions. Some of this is just, in the area, some of it was more in the Denver area, but we looked at different areas and I kind of provided some examples of what parking in Wellington is right now, and what, you know, a type of building would get you with the amount of spaces they would provide as opposed to these other jurisdictions. And so on this sheet, I know you can't read it, but it has all the different types of ratios that, you know, are in those towns. So there's Greeley, there's Fort Collins, there's Windsor, there's Severance. There's a bunch of other communities that kind of we look through to see like, all right, where does Wellington fit? Or is Wellington off, you know, way off, or are they under parking, they over parking? It's just a comparative analysis tool that we kind of do when we're crafting up these regulations. We'll go to the next slide, talk a little bit more specific. So this is kind of narrowing it down and really getting into that table. And so I didn't do an analysis for all of the uses because uses are different in each jurisdiction. But, you know, you talked about retail and restaurants. Those are usually your higher parking users. So what I did is I kind of gave an example of a type of building, and then I used a ratio that was given or that's in the code, and I calculated it out. So this first example at the top, this is Wellington's current standards for like a retail store parking ratio. It's 1 to 200 square feet. And if we use a 5,000 square foot retail building as our example, the minimum parking required is at least 25 spaces. So for a 5,000 square foot building, 25 spaces are provided. You know, you can't, that's the minimum, you know. Whereas you look at Loveland, right? It's a little bit different. They operate a little bit differently. They have different regulations. It's a bigger city, but their ratio is 1 to 300 for a same type of retail building. That's going to give you a minimum of 17 parking spaces. And parking is a big deal, not only for the developer, but for the community and for the town itself, because they have all these underlying costs associated with overpaved and overparked areas that are just wasted spaces, especially for developers. So you can see in this example, kind of the difference. So there's a big difference for a minimum 25 spaces and 17. And additionally, if you see the red here in this table, those are those maximums we were talking about earlier. So in Fort Collins, they provide a minimum and a parking maximum. So for that 5,000 square foot retail building, the minimum space required is 10 parking spaces, but the maximum is 20. And so a developer can pick, you know, do they want to provide 10 spaces or do they want to provide 20 spaces or anywhere in between for that 5,000 square foot retail building. And on the other column, the fourth column, is a sit-down restaurant. Those are usually areas or uses that have a lot of parking and a lot of people come and go. And so I did the same approach. Wellington's parking ratio is one parking space for every 100 square feet. And so for that same example, for a 2,500 square foot sit-down restaurant, 25 parking spaces are required, as opposed to if we go to Fort Collins with the minimum and a maximum approach, you have 13 as the minimum and then 25 as the maximum. And you can have a range within between those. It's also interesting to note specifically about why parking is important and the amount of space that it takes is just when I really looked more in depth with the standard parking space here in Wellington. So the typical standard parking space is either 8 by 18 feet or 9 by 18 feet, but in Wellington it's 10 by 20 feet. And so I did some more calculations, and for a 5,000 square foot building that requires 24 or 25 required spaces, 5,000 square feet is just solely parking. That doesn't include the drive aisles. That doesn't include, landscape aisles. That doesn't include fire lanes. So the building itself is 5,000 square feet. And then the minimum parking itself, just the spaces alone is 5,000 square feet. So it's kind of an interesting thing to look at to see like that's a lot of spaces dedicated to parking spaces that may not even be used, frequently. And additionally, we're about to wrap up in the next 5 minutes. I'm almost done. When it comes to these parking comparisons, it's important to see what other jurisdictions are doing and how they measure and calculate parking requirements. So You can see on this table, there's mostly numbers, but there's also some writing, like you'll see employees. So certain jurisdictions, they'll have like, they'll have their ratio, like in Windsor, it says 1 parking space for every 200 square feet of sit-down restaurant. And then plus 1 parking space for every 2 employees. So that employee metric adds to the parking requirement of the square footage metric. And they determine parking spaces from there. But in our line of practice and how we go about it, we try and reduce the amount of metrics and variables used to calculate this. And we try and keep it attached to building square footage, because one issue that, you know, a place like Windsor might run into is a local bar that's doing really well, or a restaurant that's doing really well. In this example of a 2,500 square foot sit-down restaurant with 10 employees, they're going to provide 18 parking spaces. Well, what happens if they fire somebody? What happens if they lay off 10 people, 10 employees? Their parking is going to go down. And who's going to regulate that? And how are they going to regulate that? You're telling me that, you know, this bar is going to have to, or if they expand, I got to provide more parking because I hired 3 more people. It's like, that's an increased burden on that property owner. And that's a hard enforcement. It's hard for the staff to enforce, the town to enforce. So that's a reason kind of why we try and deviate away from, you know, those types of parking variables, trying to keep it as much as we possibly can towards building square footage. Next slide. So before we talk about next steps, are there any questions about parking? We got about like 3 minutes. These next slides aren't very, you know, in detail. It's just where we're going forward and how we're going forward. Any questions or anything before we pick this back up later?
Well, I said a quick question. I've mentioned it to Cody that, pardon me, the downtown core, there's some empty spots there. And I mean, some of those restaurants provide no parking because it wasn't a requirement. But now with the modern standards, you know, you build something small and then you got to find some place to provide parking. And the questions I've asked Cody, are the standards for someone developing an open parcel down there, should those be the same as the standard someone who's building in a field where they might have a little bit more flexibility as to what they could do? So is that something that you have seen in the past?
Yeah, so that comes back to what y'all want to see and how staff wants to go about it. But what I talked about earlier, parking districts, that's fairly common. That's common. I know I've looked through Durango's code, the ski resort towns, Breckenridge, Aspen, Silverthorne. There's all types of places in Colorado that regulate their parking. Kind of, they right-size the parking with, you know, if it's in the downtown area or if it's outside and it's a green field. So that's something that we're going to rely with staff to give us direction, y'all to give us direction. Sorry, I say y'all. This is where I'm from. It's what we do.
Texas.
Perhaps. But it's just it just depends on what y'all want to see. But with the work that we've been doing in Colorado, we specifically address those issues pretty frequently, or we're continuing to work on those issues.
Thank you very much.
Any other questions?
So these numbers in here, and this is just currently what we have on the books.
Yes, sir.
Okay, so no evaluation's been done here on this in your work.
What do you mean?
You haven't evaluated whether or not this is effective or not.
Oh, no. I'm just looking at seeing, like,
We have.
from a bird's eye view. It's like, okay, so this is what we do in Wellington, and this is what they do over in Fort Collins or Windsor or Greeley. Where does that fit? How does that relate? You know, is that appropriate for Wellington? Does that fit? You know,
Well, when do we get into that?
I mean,
It's appropriate.
that's going to be with staff, more discussions, saying like, hey, we have a specific parking problem with retail uses in downtown. One parking space for every 200 square feet is not practical. You know, we need a higher ratio. We need a lower ratio. We're going to rely on y'all's expertise to let us know, and so we can carefully tailor the parking to what fits Wellington.
Yeah, and it gets back to, if I go back a few slides where we started, you know, the questions, what uses generate the need for parking? What are the parking problems? Those are local questions that we need to answer Obviously, your staff has already started to think about these things, and we've had some conversations with Logan Simpson and with White and Smith. But we've not tried to guess on what is right for Wellington yet, because that's a conversation that we all need to have. We have started drafting a lot of other sections of the code for some things that we think are best practices, general standards, things that we see everywhere. Parking, especially in downtowns, is pretty unique. So we want to make sure we give that the due diligence that it needs before we throw out there, this is our recommendation.
I don't know about y'all, but this has been very informative. A little bit. I had to throw that one at you, Reese.
Said.
Appreciate it. Thank you. Thank you. So
Good presentation.
guess we'll close this part of the meeting and take a 6 to 10 minute break so Mr. Bird can eat some supper. And then we'll get started with the meeting.
Thank you, Chairman. If you don't mind, I would like to make a quick announcement. It's about 6:31, or 6:32. So we're just a little bit behind our normal meeting schedule. I think the recess would be great to give everyone a break here. And then we'll convene the regular meeting. Following the regular meeting, we do still have Reese and Mark here to provide some additional question and answer time, best practices on some of these topics that were presented in work session, because we still do want to hear from our planning commission on your thoughts. So we'll plan on reconvening the work session following the regular meeting.
All right. Thank you.
Thank you.
All right.
Got him.
Mayor's in now. We'll call the regular meeting of Planning Commission December 6th to order. Roll call, please.
Commissioner Keeney, present.
There she is.
Whitehouse,
Here.
Hammond,
Here.
Knack, Sarter,
Here.
Friedrichs,
Here.
McCaffrey.
Here. Any additions or deletions from the agenda?
From staff.
Public forum? I have one.
You guys have a sign-in sheet, okay. Well, Christine Gator, downtown area. One thing is the minutes. I told Cody, but they haven't been corrected. There's no saying who's the nay or the yays for the 6-1 in the minutes. So just for future reference, that would be great to know in the minutes. And then I liked what the presenter said today about religious. It has to be the same as assembly. And the only example he gave was convention centers. So I don't really think that you would put in a convention center in the middle of a residential area. So I do think that the religious land use is miszoned in residential, because you wouldn't put a convention in there. And I want to reserve the rest of my time. Thank you.
Anyone else?
Good evening, everyone. Good to see all of you this evening. And
State your name and address.
my address as well. My name is Russ Brewer. My address is 6679 Cranesville Street, Wellington, Colorado. And some of you know me, not all though. I'm the pastor of Wellington Community Church, just 400 yards down the street from here, and have come to a variety of these meetings, never in this capacity, but wanted to just come and share a pastoral perspective on the zoning for religious use, and how a pastor or how a church might think about what kind of properties they would be considering. Now, you may know that we have bought property by Rice Elementary School. So I'm not really bringing this up for our benefit. We're already working on that, planning on building a church in that location. We've even got permits and approvals from you all for that. I'm just thinking in terms of just communicating and going over what does a church think about when it comes to property, and how can we overall best help the community and the churches. As you know, our church has been around since 1907 was when the building was built. The official capacity is 1915, but the building was begun, I think, either completed or begun in 1907. So we've been a part of Wellington for a long time, and we have old records that are even on letterhead for towns and businesses where, I guess, the safe paper, they just brought paper and church records were written on them. So we're that much of a part of the town. Even in our Constitution, we have provisions that the town can use our building for town and community functions. And that has happened maybe not as much in a recent decade or two, but throughout the last 100 years or so, that's definitely been a part of how we have worked together. And so we want to keep that relationship going and to continue to have that positive goodwill. When it comes to thinking through a building project, my personal experience, I've been on staff at 3 churches that have had building projects, had a very key role in 2 of those building projects. And so I have an aspect of expertise when it comes to that, plus several friends who've been part of building projects or churches I've loosely been related to. So I have some experience in what goes into it. So I wrote some thoughts down about what does a church look for and how can that then factor into your plans for the town and accommodating your citizens of this town. One of the most important things that a church is looking for is being on a high traffic thoroughfare. Like any organization that wants to be a part of the community, wants that name recognition, that product recognition, you might say. We want to be places where people can see us. The intent is to be a positive part of the community, to be a light for the gospel, and also to connect people to the Lord, and even build goodwill and relationships within the town. Even when we were talking about getting approvals for our current property, we had, every now and then when we could, we talk with you various folks. You may remember some of these conversations. We're like, how can we be a part of the community to help the community? Is there anything we could build on our site that would be helping the community, helping the town? Even when we decided not to build on 6th Street, what the town was asking of us highly factored into our decision to not build there. You may know that we own kind of part of 6th Street with y'all, right? Y'all. So we're all kind of sharing that property together. And it was communicated to us that it would really be in the town's best interest to let that go commercial, like a pure revenue producing commercial lot. And we understood that. And so we decided we'll agree to sell that and we'll look for someplace else that would be more conducive for what the town would want. So we want to be in places that are highly visible. And so some of those reasons for just being a part of the community, ease of access to the community, things like our church sign. Churches love their church signs. A lot of times they have movable letters, whether it's electronic or the old fashioned kind. They want that sign to be visible for people to see going by. It's one of their only ways they can communicate with the community is through that church sign. And if they're way far in the middle of nowhere, where no one can see that sign, that communication is being stunted. Another consideration, and I'm not sure I should say this, so just don't tell anybody else that I'm going to say this, but we want to have good relationships with our neighbors, and that's often difficult for a church. The reason is that churches are noisy. They have children's programs, they have picnics, they might do an outdoor event or something else. They make noise, they have things set up on their properties. When neighbors are right next to that property, and right next to is, anything probably closer than 20 yards, maybe 50, 60 yards. When it's too close, the neighbors hear all of that and they're just irritated. And we're trying to build goodwill with our neighbors. We don't want to have neighbors right next to it. I was on staff at a church where we had neighbors within a dozen yards of the church building. And these were constant issues. And it was very difficult to reach and be a blessing to the people when they're irritated by the volume of your events and things like that. Similarly is lighting. Now, we haven't begun that process completely, but I've been a part of the process when you work with a civil engineer, they're going to give you the square foot or the square yard lighting index for that whole property. You want a safe property. You don't want churches to have places where there's dark crevices and things like that. You're trying to be a safe, illuminated place, metaphorically as well as physically. And so that lighting can be an issue to neighbors if they're too close. And so you want to be with enough distance from your neighbors that your parking lot and your 24-hour surveillance lighting isn't causing a problem for your local neighbors. Last couple ones would be just a pure property size. We would like to be able to, when you buy property, you're thinking long range, you're thinking possible expansion, you're thinking sports fields, soccer fields, a baseball field, playgrounds. You need to have that larger facility to do that, a larger campus, should say, larger campus, and that's not always possible in tight residential areas. So with that, again, this is not for us because we already have our property, but as you're thinking about zoning, I could recognize, like looking at your map here, the Cleveland Avenue block with those purple and light blue sections. I don't foresee any church wanting to build there. It's just too small of pieces of property for us. But beyond that, most of the other places in town, especially as the town expands, those commercial areas, those areas of high traffic thoroughfares, they're going to want to be in those places. And so if you're able to factor that into your zoning considerations, I'm sure future generations would appreciate that.
Thank you, Russ.
Yeah.
Yeah. Good. Just considers you might want to email that information to Mr. Byrd.
Yeah, be happy to. If you have any questions, you're also welcome to reach out to me, kind of know where I am. I'd be happy to answer more.
Is that the old zoning map?
The map on the wall is the current, the current zoning map. And there's a couple new properties that aren't adequately reflected with our current standard, but I could.
Additional properties aren't shown on there.
Correct.
Okay.
So in other words, it's current, but there's a few updates that aren't reflected.
Right, there's quite a bit in the growth management area not shown there.
Correct. And the future land use component from the comprehensive plan is not going to show on the official zoning map. And just as a reminder, the future land use map is a vision for the community, and the zoning map is a regulatory tool. And that's why we don't show the future land use on the zoning map, is because there's no zoning established by the comprehensive plan. It's intended to be visionary for this is what it is likely to be or could be, as opposed to this is what it is and how it is zoned.
Okay. Anyone else? All right. Go to new business now. Hey, vacate 20-foot platted access easement on lot 1, Wellington Manor minor subdivision. Mr. Byrd, floor is yours.
Point of information, are we approving minutes?
Yeah, I'm sorry, we need to get to the minutes.
Okay.
I thought of the minutes when she mentioned it, and then do we have an approval for minutes or a change or?
Well, if there's the nay vote on the issue that Ms. Gator raised was, I voted no on that Meridian First Trust. If that needs to be reflected in the minutes, that's fine, if that's
Yeah.
appropriate.
And yeah, and I appreciated Ms. Gator bringing that to my attention, and staff did research the minutes, and we confirmed as well that the one nay vote on that item for a site plan review for Meridian and the Meridian First subdivision was Commissioner Whitehouse.
From his house.
Yes. And so typically, and this was a miss on my part, typically we would include the nay votes in the minutes. And I just didn't catch that one. So we would propose amending the minutes as presented to reflect the 6-1 vote with the notation that the nay vote was Commissioner Whitehouse.
A motion?
So I move we approve the minutes from our meeting of
November 1st.
November 1st. Thank you, Mr. Byrd.
Second.
Very seconded. Roll call, please.
Commissioner Kinney,
Yes.
Whitehouse,
Yes.
Hammond,
Yes.
Knack,
Yes.
Sarter,
Yes.
Friedrichs,
Yes.
McCaffrey.
Yes. Apologize for missing a minutes there. I wrote Ms. Gator's name down beside the minutes for that reason and then went right past them. Okay. New business, vacate 20-foot platted access easement on lot 1, Wellington Manor minor subdivision. Mr. Byrd.
Thank you, Mr. Chairman. I got distracted by the minutes comment and don't have the PowerPoint presentation pulled up for this. So give me 1 second while I navigate to that. I did promise to Isla Droman, the applicant, that we would make this as easy as possible. For many of you, you know the property that's being considered. It's on Highway 1, Cleveland Avenue. It's the Droman Salon. And the request tonight is for a vacation of a 20-foot platted access easement. Here we go. This isn't maybe ideal because I didn't have the PowerPoint open, but I want to keep things moving. So this is just from the agenda, directly from the agenda packet. So the requested easement is located on Lot 1, Wellington Manor minor subdivision. That minor subdivision was a 2-lot subdivision. It created Lot 1 and Lot 2. ADJOURNMENT is the applicant, is the owner of Lot 1. And Vicky and Bruce Beckner own Lot 2, which has access to Harrison Avenue, and this is 4th Street here, which here's your location map. Illustrating Lot 1 is highlighted as the applicant property, and that platted access easement basically covers the drive aisle from Cleveland Avenue to the back of Lot 1 for the purpose of providing access to Lot 2 to Cleveland Avenue. In this particular request, Ms. Droman has requested to vacate that access easement. It is shown on the plat, so it's an amendment to the platted document that the Planning Commission reviews, and the Board of Trustees will make a final determination on that amendment. The request itself is fairly simple because there's only 2 properties that access easement impacts. In this particular case, excuse me, the Beckners, the owners of Lot 2, have joined in the request or the desire to vacate this access easement. They're the primary beneficiaries of that easement, and they submitted a letter, which was included in your packet, stating that they agree with and support the decision to, or the desire to vacate this access easement. When staff took a look at this, we looked at, does Lot 2 have adequate public access to their lot? And there is adequate access off of Harrison Avenue and 4th Street that would support development or redevelopment of that Lot 2. So staff doesn't have any concerns with the proposed vacation of the access easement, and we do support that, the vacation. The slide I'm showing currently is just kind of zoomed in view of Lot 1, Droman Salon, and the access easement. It's 20 feet wide and generally follows the driveway through the parking area back to Lot 2, which is owned by the Beckners. So if this vacation request is approved, essentially what you would see is the same plat. Everything would remain the same. There would just be a notation that would show up in the on the town's records and in the deed and title for both these properties that 20-foot access has been vacated, meaning there's no longer a right for the public to cross Lot 1. There's no property ownership changes being associated with this request. All of the land underneath the access easement is still currently owned by Ms. Droman, and vacation of the access easement doesn't convey or change any lot ownership. This is a public hearing item tonight. I've given you the general staff presentation. If you have any high-level questions of staff regarding what is being requested, I can answer those now. Following that, we would invite either Ms. Droman or one of her representatives to expound on any information that I might have missed regarding their request. They'll be available for questions, and we would want to allow public comments as well, if any. Following public comments, staff can respond to any follow-up questions and make closing remarks. And then we would turn it back over to the Planning Commission for deliberation and a vote. The Planning Commission's deliberations come in the form of a recommendation that would be forwarded on to the Board of Trustees at the January 11th, 2022 Board of Trustees meeting. And again, our staff recommendation is to approve that request for vacating the 20-foot access easement and forward a recommendation on to the Board of Trustees. Any questions for staff regarding this request? Ms. Droman or Mr. James, anything else that you wanted to add from the applicant's perspective? Okay.
All right.
It's all yours, Mr.
You can
Chairman.
close this part of the meeting and open it to the public then. All right, close this part, open to the public. Anybody in the public have anything you want to say? All right, close the public meeting, bring it back to the board. Have any other questions or concerns for Mr. Byrd?
No, sir.
Do we have a motion then?
I have one. You kept
Too late.
saying, I'm looking at the map here, the aerial view, and you've said several times tonight, and at least once in the paperwork, that the access for the second property, the second lot, is Harrison Avenue and Fourth Street, but it looks like it's Harrison and Fifth Street.
Thank you. You are absolutely correct, and I apologize for the misstatement. And if that's in the staff report as well, that is a mistake. The secondary access is from Fifth Street.
Now that's in page 49 of the packet.
My apologies for that oversight. That Fourth Street should be corrected to say Fifth Street.
Thank you.
Oh, thank you. Good catch. Does that clarification make sense to everyone?
That doesn't impact the motion or
No.
anything moving forward with allowing the vacation, correct?
Correct. That'd be my opinion. Obviously not intended to say that there was access across other private properties to Fourth Street. That would make a big difference. But correct. As I take a look at that, the correction to from Fourth Street to Fifth Street doesn't actually change any of the other substantive matters for the case.
You call, Barry.
Thank you.
Any other questions?
No, sir.
We have a motion then.
I'd like to make a motion to vacate the 20-foot platted access easement on Lot 1, Wellington Manor Minor Subdivision. That was
Oh.
major.
Second.
Roll call, please.
Commissioner Kinney,
Yes.
Whitehouse,
Yes.
Hammond,
Yes.
Knack,
Yes.
Sarter,
Yes.
Friedrichs,
Yes.
McCaffrey.
Yes. I think the motion passes. Thank you.
And again, just to reiterate, that recommendation will be forwarded on to the Board of Trustees at the January 11th, 2022 Board of Trustees meeting.
Any other announcements you have for us and before we close this part of the meeting and go back to our?
Yes, I have a couple of announcements. Some of you may know, and those of you who maybe haven't heard yet, probably observed that our planner too, Liz Young-Winnie, is not here tonight. Liz has resigned her position with the town. She had another opportunity that was presented to her in the Colorado Department of Public Health and Environment. And we're very, very excited for Liz to take on a new aspect in her career. But as many of you know, when you lose a person, you start to find out just how much they actually did for you. So we're very sad to see Liz go, but she's been a great asset for our team over the last year and a half. We're sad to see her go, but we wish her well in her future pursuits. If I'm behind on communications for any of you, and I know at least one I'm behind on a communication, it's because I'm being reminded just how much Liz did for the town. So bear with me, and if you need to remind me that I'm missing something, please send me another communication and bring it back to my attention. So we're sad to see Liz go. We wish that we could have her here longer, but we will be looking to fill that vacancy as quickly as we can and get some additional planning support staff here.
Good.
The other thing I was going to mention tonight, two more things actually. I'm going to send the Planning Commission and our Board of Adjustments an email with some information. The county has created the Larimer County has created a task force group for climate smart. That's an initiative that they're trying to receive input on. And I'm just going to send it on to you. There's a meeting next Monday, December 13th in the evening. It's a webinar and they're presenting some information and seeking some feedback. So if you're interested in what the county is working on from a climate smart perspective and they're seeking guidance on regulations and other things relating to climate, I want to make sure that our Planning Commission and our Board of Adjustments have opportunity to hear what's being said and provide any comments that you feel is appropriate. So look for an email from me with that information. I'll provide you the link to that meeting. And then my last comment was going to be regarding the January Planning Commission meeting. Staff understood from the last meeting when we adopted our 2022 schedule that there was a conflict with the first meeting of January with regards to schools being open or schools being closed and the New Year's holiday. So we moved that to the second Monday of January. We don't currently have any applications for that meeting for action items. We do anticipate continuing to have the work session for that meeting to continue our work on the land use code updates. So I just thought I would share with you that we don't anticipate any action items. We do still plan to meet to discuss work session items for land use code.
Okay.
Those are my announcements.
Thank you. Very informative. We have any other questions for Mr. Burden? All right, and at 7:06, we'll adjourn this meeting. Thank you. And go back to the plant work session.
Thank you.
Floor's yours again.
All right. Thank you, Chairman. And thank you to our applicants, Ms. Droman and Mr. James, and to Mr. Brewer. Thank you for attending and speaking on our public forum. We do want to continue, or at least provide the opportunity to continue on the work session items that were presented at 5:30. We understand that the land use discussion is a very broad topic that needs to have some due diligence on those various subject matters. So we wanted, and we presented a lot of information to you in that initial presentation. Thanks to Reese and Mark for really diving in on that presentation. But we didn't end up with a lot of time for you to ask any questions or provide any feedback to staff or Reese and Mark and our consultants. So that's what we really wanted to do with this last bit of time, is make sure that we can have that dialogue on the work session item, being the land uses, the land use table, definitions, observations that you've had from the community that you live and work in, what's working well, what's not working well. And in particular, if you've got questions regarding process, best practices, how do you deal with those challenging land uses like adult entertainment, wireless telecommunications? We've got access to Reese and Mark tonight, so we really want to take advantage of their time to cover those topics thoroughly. So with that, are there any questions about the presentation materials that were presented? Questions and/or what are your reaction comments to that information?
Well, I was thinking about the wireless tower and the last there seemed to be some, I don't know, confusion about whether I mean, at least in my mind, whether we even had standing to try to, because of the federal protections for telecommunications. Is that going to be clarified within our code sections this go around, or is it just more of an educational component that I might need to understand better? Because in that process, I had inquired with the town attorney and I didn't seem to get a lot of clarity as to whether we really actually had any say in it, so.
Yeah, so, and I'll let Mark respond to this in some ways with his expertise on the subject matter. At a high level, though, I think what we're proposing as a staff is our current standards related to wireless towers and wireless or telecommunications facilities doesn't adequately address current technologies. There are some sections that we know are in conflict with federal laws and regulations. So at a minimum, we want to get this cleaned up to reflect current industry standards. We want to clean up and reflect what we as a municipality can actually regulate on that subject matter and make it very clear in our code what our expectations are on the items that we do have some control over.
Well
Anything
said.
you want-
I don't really have anything to add to that. Other than, there was the Spectrum Act that passed a few years ago that dealt with 5G and just what they call distributed antenna systems. And so we'll need to make sure those had some additional provisions in them. And so we'll make sure that those are covered as well. Frankly, every time I do a telecom, I have to go back and reread everything I did before. There's such the federal regulations are so complicated, but yeah, we just want to make sure they're adequately addressed.
Okay, thank you very much.
Thank you.
I have a question. When we're talking about like best practices, outdoor storage, display, things like that. We currently have a couple businesses on Cleveland that do have outdoor display items, things like that. Are they also considered under the current use? Like they are currently allowed to have, or they currently are displaying items on a sidewalk? Are we talking about that's going to change? Because I know use is what we're using it for now. Will continue even if our zoning changes.
Yeah, so I think it's twofold, and then I'd open it up to, I know Reese has some expertise in this, and Mark, if any comments are there as well. Generally speaking, our current land use code doesn't do a really fine job of defining what is outdoor regulation, what is allowed for display, sales area. What I would caution is that we want to probably not get in the way of a business's operations in terms of having the ability to do a sidewalk sale and have adequate displays. But there are other provisions that aren't currently addressed, like how much area does that consist of? Are there hour restrictions? Is it on a public sidewalk? Is it impacting ADA access or egress from a building? There's some other factors in there that need to be identified, not just for our downtown businesses, but for all of our commercial zone districts. And a kind of a classic case, and you might hear it over and over again, our current code just doesn't really identify a lot of these questions that should be identified in the code, so that there's clear understanding of what's allowed and what's not allowed.
And I would, bring up to the, screening, buffering example too, if that is something that we're looking at adding this that will affect current uses, or I guess you probably, or is it just new businesses coming in?
Yeah, so typically the way any change to the zoning code is addressed, if it's legislative in nature, I mean, it impacts all of the districts and businesses the same way, as opposed to a site-specific, you on this property have to do this way. If it's general in nature and applies generally to the whole town, then any new business use established would have to follow those criteria. If it's an existing business use, if there's significant changes to the site, a remodel, expansion of that use, change of use, so it's the same site but a different business and they're changing the business operations. Some of those are thresholds and triggers to reevaluate if that site needs to be brought up to the new standards that might include outdoor display, outdoor screening and buffering. And we can define what those thresholds are. So this question is maybe two-part. First, to address the question, does it affect existing businesses? Probably not, unless there's a significant change. The other question is, what are the standards that we want to look at in terms of screening, buffering, outdoor display areas? And what is the trigger or threshold for an existing business if those do need to be factored into? We can define all of that in our land use code so that there's clear expectations on how that'd be handled moving forward. Anything you want to add to that, Reese or Mark?
Yeah.
No, you wanna add something?
No, I was gonna say nonconformities, our nonconformity section will address exactly what she's talking about. So.
Yeah, good point. We haven't even really broached the topic of non-conforming uses and non-conforming structures, which is a really fun section of the code to enforce.
That's all I own.
This is your guy for nonconformities too.
Tim's just non-conforming, right?
I have a question based on the land use associated with federal or state regulations. Would our land use just reference those, or would they be built to align with them? What happens when those federal regulations or state regulations change? Do we have to adopt a new land use code at that time to make those amendments? Or does it always just reference those outside regulations?
Yeah,
Yeah.
that's a good question.
Go ahead, Mark.
It's a little bit of both. A lot of times we will reference some such and such as defined by, we'll reference the Colorado Revised Statute section, and we can say, we usually have in our definition section that includes any amendments, so that when they amend, 3 sessions from now, they amend that statute, we don't have to turn around and amend our regulations. It just automatically becomes part of them. But let's say the telecommunications statute is amended 2 years from now and adds a whole new set of things we have to think about for some new wireless technology, well, we'd probably have to turn around at that time and then incorporate those specific provisions into the new zoning code. This is always your zoning ordinance will always be a work in progress because of that. You'll have new court cases, you'll have new statutes, you'll have sometimes changes in land use policy, and all of those will require amendments from time to time.
Thank you.
Answer your question, Rebecca?
Yes, yes, it does.
Cool.
Thanks.
Can I ask another question here? So you got these yellow cells that require guidance being requested from the planning commission, the proposed zoning district. When are we going to deal with that?
You're referring to the land use table that was
Hmm.
included as a draft in the,
Mhm.
I mean, so this is a great time to provide any comments or thoughts on those uses. That land use table, again, and this was the same version from the November meeting. We didn't
Yeah.
change anything between the two meetings. But this was kind of a first blush from a best practices type of standpoint and initial recommendations. We can identify changes to that, tweak that, or just have conversation. If there's questions that the planning commission has regarding some of these items, we can bring back some additional research or information on specific questions. So this is a great time to start that conversation if you've got any thoughts on it.
Well, I had a couple comments after hearing Russ Brewer speak. I mean, how does that line up his thoughts about relationship and noise and space and expansion? How does that line up with, I'm trying to find it right now, the sort of proposed, I guess, religious land use? I mean, can you speak to the appropriateness of that and whether it is reflected in what we're proposing here as well?
I think I can start with an explanation. And first of all, much appreciated to Pastor Brewer for coming and sharing those thoughts with us, because it's really helpful in how we look at any kind of change in regulation or change in recommendations for land uses. I'll start by saying that the current code currently allows religious land uses as a use by right in our C3 highway commercial zone district. And a lot of the conversation that we heard in the past and regarding some specific requests was that maybe that wasn't the right fit for highest and best use type of scenarios for the town's long-term growth and viability. And Pastor Brewer alluded to that in his comments tonight. Whether that's the will of the town moving forward, I think what we would like to pose as a staff is that this is the time when we're considering our land use code update to make sure that we've identified an appropriate amount and availability of land for those uses. We know that our churches are all facing growth pressures as we add more residents and they add more constituents in their congregations. Their existing facilities are going to outgrow their footprint and they'll need to look for new locations. When that happens, do we have a good way of accommodating that additional need within our regulations? Mark, and maybe some best practices from a regulatory standpoint?
Well, I think what the pastor was talking about, is not inconsistent with where I was coming from too with Ray Lupa compliance, because, well, in C3, like for example, if we allow movie theaters, we can't disallow churches. Movie theaters are an assembly type use, and we can't say you can assemble for purposes of watching a movie, you cannot assemble for purposes of worship. We just cannot do that under federal law. So as this use table evolves, we need to make sure we're paying attention to every place we allow an institution and every place we allow some sort of assembly type use. We need to make sure that not only number one, we have to allow religious land uses in the same way. And we have to allow them on at least equal terms. So for example, you know, if we allow a movie theater by right, we can't require a conditional use permit for a church. That would be stricter. And that would be considered discrimination against religion under Ray Lupa. So those are the kinds of things I'm kind of looking out for too, as we do the table. I think the things the pastor was talking about are things that are going to evolve anyway, you know, from the use table. A lot of communities also deal with churches and you know, a lot of them allow them in residential districts too. I'm not sure if y'all do. Even though those aren't the preferred locations, sometimes you'll have a smaller building where a denomination will start. That's where they start, and then they grow, and then they move, and they find another building and that sort of thing. So that's something we'll need to look at. And another thing I didn't get into earlier is the use, but I did take a look, make some notes over the weekend, is your sign regulations. And he alluded to signs. They need a lot of work. The nice thing is that they're only 2 pages, which is great. I love it when I'm trying to watch a football game and I find out, yay, it's only 2 pages. I can go back to watching the football game. But the bad thing about it is it's only 2 pages. It leaves a lot of questions unanswered. There's too much discretion, like for approval of the signs near the interchange. It literally says this within the unfettered discretion of the board. You cannot do that. You have to have standards. You have to. And so we'll need to put some standards together that the community agrees are appropriate for those and just codify them. And, you know, he mentioned churches too. I deal with this a lot when we have sign regulations, especially for residential districts. We have to allow an adequate number of yard signs because, you know, when elections are going on, yeah, people complain a lot about political signs, but they're a form of speech. And so we have to allow a sufficient number of yard signs that people can speak that way. And we can't discriminate between signs based on their message. We have to get rid of all of that in the code. And I've worked with another community recently that only allowed digital signs for churches. Well, that's a great thing, but again, that's a user preference and we have to avoid those too. If we allow digital signs in residential, it has to be for any non-residential use, I would think. And you know, that's just an example. I'm not saying we would allow digital signs at all. Your sign regulations don't even address those, but we'll need to avoid those kinds of distinctions in the new sign code, but it needs a lot of work as well.
Yeah. And
So
If we didn't allow them in C3, where would we allow them?
well, churches are digital signs.
No, the churches, I'm just saying, for example, that, you know, he kind of related to the fact that the residential areas weren't large enough. So if you don't allow them in C3, where do you allow them?
well, and I would ask a broader question, is C3 even a zone district as we move forward? Is there a different factor or standard for, you know, traditionally you see industrial, light industrial, and those are separated into heavy or light. You see commercial districts that can be divided for a number of purposes. We have a downtown specific corridor. Our C3 highway commercial currently addresses the interstate I-25 corridor as well as the Highway 1 corridor, but we don't have any property annexed into the town for commercial purposes on Highway 1 going south. That is an entirely new highway corridor. Is C3 the appropriate zoning use for that corridor? Or is there a different standard that needs to apply for that corridor and those uses? So I think that the context that Pastor Brewer shared with us regarding what is it that the churches are looking for, the visibility, high traffic areas is really telling. Historically, the town of Wellington, as we've grown, has been primarily for residential growth. So I think it would be a strong consideration for staff to make sure that we've allowed for religious uses in some of those residential areas, whether it's a permitted use or a conditional use, to make sure that option is available for those considerations. We've had instances where private or public entities have negotiated to buy land from a developer that was only interested in residential development, and they negotiated that property for non-residential uses. That's another example. And then they, the lot size question was the same for that particular user. A residential lot doesn't make sense for them, but assembling 10 or 12 residential lots into a couple acres made perfect sense for them. So there's definitely a lot of nuance to it, but I would err on the side of let's allow flexibility for those users to find the property that makes sense for their needs.
So all these things we're talking about tonight, these are things you guys are constantly working on through this whole process, right?
Yeah, my suggestion would be that your professional staff and our professional consultants are looking at what has worked in other communities, what are best practices that have evolved over time. We're making recommendations based on how we see those things work and what is legally defensible. And we need the context from the community of what does our community desire. So we can build a framework around defensibility, best practices, other things. We still need the local conversation to make sure those are good fits for the community. And as far as the conversation goes, it's going to be probably ongoing until we make a final draft recommendation for adoption. This is overall, the land use code is very broad, as we've mentioned before. And even as Mark alluded to tonight, as we make changes to one thing, we have to go back with a broader lens and make sure that if we made that change, did it create a ripple effect in the other requirements, to make sure that everything, when we're done and present the final draft, that everything is in alignment and we didn't unintentionally create a conflict. So we will be continuing to have these conversations through to the end to make sure that everything works together.
What is the goal to finalize this thing?
What we had contemplated is that this would be presented for final draft in March. We do have a grant with DOLA, Department of Local Affairs money, that we have a timeline that's been extended twice because of COVID. And they would really like for us to get that completed and close that chapter, and that expires in May. So our goal is to complete that process and close that grant application within that time frame.
I have a couple questions. When and how are we going to add the proposed use for dispensaries? And then also, if we are considering excluding C3, how would that be impacted by the current language that was passed? And then thirdly, and this isn't a question for today, but something I would like follow up on is, how do we avoid liability if there were any kind of conditional use requirements and then that was used to block certain businesses or proposed uses from entering the town? And that could be for any use, but I primarily see that as a concern for legal concerns in the future based on zoning language.
So Commissioner Kinney, I'm going to start that conversation. I'm going to give a lateral to Reese and Mark, and then because you had a multi-part question, remind us if we missed something. I'm going to start it off with, I made a comment that is C3 zoning the right zone district. I'm not suggesting that C3 is off the table, but more specifically looking at where that definition is applied, that its current context is for highway corridors. And as the community grows, our highway corridor is going to extend and include Highway 1 going south that might have a different look and feel than the I-25 corridor. And so that was where that comment was directed, is that we need to make sure that we've got the appropriate zone district for our anticipated growth areas as well. Maybe remind us on part 2 and 3 of the question. Sorry. One of the other questions was, when are we going to include marijuana uses and dispensary uses? We're going to be working on that starting very soon. We haven't brought that topic up because of the pending election results. But now that we've got an answer on that, we will be bringing that forward with some draft best practices and possible recommendations. even, and I should say too, had the vote gone the other way, I would still be here as a staff member recommending that we put those regulations in place in our land use code. Because it's looking at it from a land use perspective, we're simply defining the time, place, and manner of those establishments. Where can they go? Where are they appropriate? What are the setbacks? What are the conditions that they have to meet if they're going to be allowed? Even if the vote had gone the other way, I still would have recommended that those are standards we need to include in the land use code. Now, if you don't mind reminding us, was there another part of that question that we needed to address?
Liability associated with zoning. If there was some requirements for an administrative or conditional use approval for that kind of proposed use, and instead that was used to block businesses from entering the town rather than to meet requirements, what kind of liability and legal concerns could we be involved in?
Maybe, Mark, do you want to field
That's
that one?
specific to the dispensaries or any business?
I mean, I guess that could apply to anybody, but the specific example right now is probably top of mind for most people would be the dispensaries.
Right, I think for what we typically do when we write the code in is we have a procedures section that lays out the workflow, a common workflow for all the processes. And for anything that requires discretionary review, we set up the process so that people know how public hearings are conducted. They make sure there's due process, that all sides have an ample opportunity to put, evidence in the record, that we lay out a way for the decision maker. And I know with the conditional uses right now, it's the Board of Trustees. So there would be a requirement in there that you have findings of fact and conclusions of law based on the evidence in the record and so forth, so that, you're making your decisions based on the record and in front of you, and not just on, a plebiscite or something like that. So all that said, that puts you in the best position to defend a lawsuit that was brought by a business that was burdened by conditions that came out of a conditional use permit or something like that. You can never avoid, and any attorney will tell you, I mean, anyone can sue. We all know that. And, liability is always possible based on any number of things, but we plan to set up the code so that we have minimized your exposure to that and given you the best opportunity to make decisions that avoid your exposure to things. And, we told you tonight about some specific uses or things where, of course, we've been around the horn before on those uses that raise unique issues related to the First Amendment. Those are the SOBs and signs and those sorts of things. And, that's one where there's a lot of litigation. I mean, a lot. Sometimes I know in the past, there have been times where it seemed like every other lawsuit or every other reported case I saw in a state was brought by one of those adult businesses or signs, those sorts of things. I mean, it's just too easy for them to get into court. The standards are very favorable to them in a lot of ways. So we want to, we've been around the horn, done our research, and believe we can set this up in a way that minimizes your exposure if you depending on how far you choose to go in your regulation of them. So a lot of work to do in the code to make sure we've taken care of that. So hopefully that answers your question to the extent that it's possible to answer it.
Yeah, I think from my perspective, in my role, utilizing the land use code to minimize the risk to the town for really expensive litigation is going to be a huge priority, right? So that's the only reason I brought it up. And I kind of, as we go through that process, is you identify those red flags or things that generally cause those kind of costs or concerns. If you could really highlight those for us so we can think through and understand how that works exactly, or what historically in other communities they have seen and have been sued for, and how that was resolved so we can avoid that altogether.
Yes, we certainly do plan to do that. So thank you.
to add a little bit, since you're up there, Mark, when you first brought up marijuana, there are no federal guidelines or restrictions for dispensaries or marijuana yet. Whatever we do in our code just has to abide by state.
We're gonna, look at the Colorado regulations.
Cody, do you have those
We can, do you want a copy?
easily accessible?
We can make it accessible.
Yeah.
Yes.
We can send you a link.
Interesting
Yeah.
for all of us to have. Thank you.
Of course.
So when you go through here and you're just going to decide where you're going to want your adult entertainment establishment, we haven't done that yet, right?
No, sir.
No, we got to do some homework on that, right? Got to figure out how much land you got to give them, that sort of thing, and where to put it, right?
Yes, sir.
I assume that we're probably looking at industrial, if I heard people right.
It's already in the code, I believe that way.
Is it?
Light industrial.
Well, then you're going to need to open that up to religious organizations too as well, I believe, because right now they're excluded from that area.
If correct me, but I don't think that the intent was that assembly uses and specifically sexually oriented businesses or adult entertainment are in the same category. That they are generally both commercial, but we can distinguish between those assembly uses and the specifics related to a sexually oriented business.
I don't know, I can think of some that were assembled. So, I mean, there's something there. There's something there. There's some overlap. that needs
We'll
to be
take a
looked
look
at.
at that.
There's
I
some
think-
overlap. You can't, if you had a club or something, right now, religious land use, they're not, they can't go up there. So I would like to make sure that they're, we do that right.
Right, we'll take a look at that, certainly.
If they don't go north into the industrial park, seems like they're gonna go south to where that other industrial park is.
Yeah. Well, that's light industrial down there too, right? So they both need to be, well, you know what I'm saying? Right now, they're not considered.
Yeah, we got it.
Okay.
So is there a limitation on how many feet they can be from a housing subdivision?
Is
Legally?
there today? I can't recall the top of my head.
750 feet, I believe.
Yeah, for,
The rec line is-
yep, that's exactly right.
That's
Our-
for an SOB?
For our current code, yes.
750 feet between
750
a
feet.
church, house, and a civic
Schools.
center, school.
Yeah, schools and public property, so
Yeah,
parks,
yeah.
Yeah.
So,
That's our current town code.
correct.
correct, within the industrial zone district and
Can-
still subject to those.
Can you legally
separation.
make that bigger?
Thanks, Bert.
We would have to do an analysis of your zoning map to see how much land that leaves remaining. Right.
I'm just saying if it's possible.
At 30,000 feet, yes. I mean, you can. But whether ultimately you can do it will depend on how much land that leaves left over where they could possibly locate.
Is that kind of where this whole process starts then? Is adhering to those percentages of allowable land for those uses and then work
Right.
down from there?
That's a good way of looking at it, certainly.
Dreams Only they're called SOBs.
Just shorthand.
I forgot they were even called now because the SOBs in my head.
I was not referring to you.
Yeah, to be a first.
Were there, I mean, we know that there's going to be some homework to do on some of these other items that are more complicated in nature. But what about some of the less complicated businesses like restaurants and sit-down restaurants and restaurants with drive-throughs? I mean, those are still questions that we're going to include recommendations for in the land use code, and they're in your land use tables. I mean, certainly we can dive into all of the more complicated land uses, but I do think that this is a good opportunity too, if you've got questions about some of these other uses that we've identified in this table, industrial uses or light industrial uses, what's an appropriate mix. This would be a great time to work with our staff and Reese's experience and Mark's experience to identify best practices. So are there questions relating to, I think the light industrial question is really important for Wellington and getting that mix right. So that's my suggestion, but if there's other uses in this mix as well that we want to discuss, this would be a great
Go
time.
right to that. I just have a question about,
Yeah.
for example, a building comes in, it has a brewery in one end, and there's 2 or 3 other small businesses in that same building.
And a grain
And then one
elevator
of those
too.
buildings goes out of, one of those businesses goes out of business, has 3,000 square feet in it. Can we still limit that business that comes in there because of lack of parking? Legally? I mean, if there's a 3,000 square foot space left and a space that barely has parking for what was in there with just a brewery, can they come in and say, I want to put a restaurant in here? Even though there's not really enough parking at 100, at one parking space per 100 square feet?
Yeah, I'm going to repeat your question kind of back to you to make sure I understand what you're saying.
An existing building.
Yeah, existing building, business was in there before, they're gone now, new business comes in.
And the buildings, that the
And-
businesses were in there before weren't required to have.
Weren't required to
much
have
parking.
parking. I think when that business turns over, we can say, I mean, if it's a change of use, we can certainly say, yeah, that if we have parking tagged to that use, then they have to, we can say they can count the parking that's there, but if there's more that's required, then yeah, they might have to add parking. So there's a lot of different ways to sort that out. But I think we can do that since it's a change of use. It's not us coming in where a business is already there and legally established and operating, and then we just come in and say, oh, by the way, you got to add more parking and land. We're not going to do that. But when there's changeover, I think we can do that. So.
Okay, go to the industrial. What do you want to talk about?
I was just gonna throw it out there. I mean, we've got, within our current code, we've got a light industrial zoning district that includes anything from childcare facilities to manufacturing, warehousing, food production. There's quite a mix, and I guess is from my experience, the way Wellington's light industrial use mix currently exists is basically a catch-all. It didn't fit into industrial and it didn't fit into highway commercial. So everything that's left is going to be called light industrial. I don't think that is really serving the purpose. And I think that down the road, as the community continues to grow, using that light industrial standard to appropriately identify uses more commensurate with the more industrial side of that and not restaurants and breweries, bars, taverns, and childcare facilities, I think would serve the community better in the long run than having such a wide use of non-compatible land uses in light industrial.
Well, I mean, I've always been surprised that the 2 companies that manufacture steel, structural steel and advanced tank, are light industrial. I mean, I'm not entirely sure what qualifies as heavy industrial, if that's not it, but any clear idea what heavy industrial use is?
Refineries.
Yeah, go ahead, Reese.
And heavy industrial would be like your refineries, toxic waste, anything that's doing like possible heavy, heavy
Commerce
stuff
City.
to the environment. Usually most cities, most towns don't have a lot of heavy industrial uses because they usually don't occur in a town. Usually it's a general industrial or a light industrial category. Back again, Cody was talking about it, it's a catch-all or whatnot. What's important about what we brought forth today, especially with the use regulations, this is something that can really be beneficial for a light industrial category. So let's say, 5,000 square feet, that's a 5,000 square foot building, a light industrial building's fine. Doesn't matter what's going on in there, but anything over 10,000 square feet, no, we can't do that in this district. That's another way in which use regulations can be really handy for going about handling different types of industrial uses.
What is your thought on those?
I think any recommendation needs to include some use standards. And going back to the presentation that Reese did, the outdoor parking, outdoor storage and display, lay down yards, I think all need to have, or I'm sorry, outdoor storage, not necessarily outdoor display, need to have screening and buffering requirements associated with them. Especially where it's along a public corridor or where it's a transition between land use types. Our current code doesn't provide a whole lot of guidance or requirements on what those transitions between land uses look like. And until 2 years ago, when we addressed the parking surfacing requirements, didn't include anything related to screening of those outdoor storage areas. So those are, I mean, certainly some use limitations that I think need to be evaluated for appropriateness and how it's applied. I think that there are businesses in town like Advanced Tank that is a tremendous contributor to our community and a really valuable asset that has a really pretty clean site that they keep, considering how much square footage they've got there and the types of activities that go on that site. That's probably as close to a heavy industrial type of land use that we would likely want to see. But then there's other businesses that would fit that same kind of categorical standpoint that don't really have any use limitations identified for them. We see kind of periodic requests from companies that do various activities in oil fields. And a lot of those sites that get used for equipment storage, muster areas, equipment maintenance don't have adequate standards associated with them. So it's hard if there's a new industrial park or a new development proposal that wants to include those types of uses. We don't really have good provisions included in our code for how to address those uses. When you look at our existing code, there's a variety of bars, taverns, restaurants, et cetera, allowed in light industrial. And if our light industrial mix is intended for like contractor offices with associated vehicle storage, automotive repair businesses, there's a variety of uses there that we should evaluate. Our restaurants and childcare facilities really the appropriate mix to include with those uses. So those are some of the kind of initial thoughts that staff has had that we could really use some conversation and guidance on how does this community want to move forward related to some of those specific land uses and what use limitations might be associated with them.
If I might throw on top of that, okay, to aid with that, right? Right now, light industrial is an overflow for us right now, seems to me, because that right there represents most of our current zoned area. There's not a whole lot of area outside of what that is that's zoned, right?
Correct.
That's
So-
the map. That's it.
Correct. Every property that's annexed into the town of Wellington.
Other
has
than
a-
the school
Correct. The school's not
and
shown on that
maybe
current map.
the country lanes, okay, or that's coming up, right? That's it, and Saddleback probably. Right now, that's all you got to work with. That's it. So you really need your land use map up here to actually see what else is division that you can go with and apply this to it and what you might use over there. That's what I'm thinking, because you're actually running out of room for what we have left. If you think about it, there's not a whole lot left.
Yeah, and I think if following your train of thought, it's a good point that in light industrial is a great example. We have 1 or 2 vacant lots in the Fox Elder Business Park. We've got 2 or 3 lots left in the Wellington Business Center with development proposals approved and 1 or 2 more yet to be created. But light industrial along First Street is nearly 100% occupied, subject to maybe some redevelopment. But yeah, like there's just not land available to accommodate a new contractor yard or a mechanical HVAC business. We just don't have a lot of land available for those types of uses. And when we find ourselves in that situation, those types of uses that might otherwise be light industrial begin looking for, well, where can I locate? And that goes to probably C3 highway commercial, which is also in short supply. And so finding the balance of what are the needs of the community and are we providing for it from a code standpoint will enable the planning commission and the board when we annex new properties to evaluate. These are our needs. This is what's available. This new property is proposed to come into the town. What is the appropriate zone district for its location and our needs?
I agree that we need to get daycares and restaurants out of any kind of industrial zoned areas. And I would like to consider the C3 highway commercial along Highway 1 and those type of uses to be really open to other commercial uses and options too. Definitely drive-in businesses, restaurants, retail, and maybe other things on a larger scale. So I would like to consider that too when we're envisioning an area for new proposed use for commercial uses. I think that should be an area that we target and imagine what would be in that area, because that's where the most traffic will be. There's so many homes along Highway 1 now, right along that side of Wellington, and then the high school use there. So that's some of my feedback for consideration.
As I recall, at one time, there was discussion that town would eventually expand all the way up to Owl Canyon. There was talk of possibly putting in retail, truck stops, a small shopping center with entertainment venues, all at the intersection of Owl Canyon and our 6th Street, and putting in maybe a public swimming pool and ice skating rinks and things like that. And you could do more things in that same area. So then if that were to come true, then anything we do north of Cleveland on 6th Street will need to be able to provide a way for people to get there. And anything that gets built might need to be 4 lanes and curbs and gutters and everything like that, going all the way to Owl Canyon. And so where does that fit in? If that were to happen, where does that fit into what we're discussing now?
Sorry, I'm trying to do a screen share here and open the appropriate file.
I need that for reference.
So, and to your point, Mayor, there it is. I'm working on getting it up here for you. It's it doesn't fit the screen real well with the as long north-south orientation, but just to get your reference, this is our future land use map from the comprehensive plan. And so here's Owl Canyon Road. Here's the interchange with I-25. And then further south, here's Highway 1 interchange right here.
And we already looked at that as commercial
Correct.
for a vision, okay? Now, we're not medium density residential. Then you've got some purple on the other side of that, which is probably light industrial, right? What is that?
Which area are you referring to, Mayor?
I'm just following it all down.
Just, okay.
The logic, you know?
Yep.
And mixed use, okay, so where did we, light industrial is hard purple, so we're really trying to just keep it all up there, it looks like to me, huh?
A lot of the consideration in the future land use map for industrial and light industrial was being able to accommodate those types of uses where there's easy access to the highway. And so the I-25 interchanges, there is a rail spur just off of County Road 7 as you go north of town. So rail access was a consideration, as well as just the general compatibility. The area being close to an interstate highway and sandwiched between the highway and the railroad doesn't lend itself to a large residential development. And so it was identified that the industrial, light industrial would be a more logical use for those areas. It's not set in stone because it's
Yeah, right.
guidance,
it's
but
guidance.
it's based on a series of factors relating to access, general land use types, general compatibility between districts for painting a scenario for what is likely to occur or be requested.
And that's your commercial up there at Out Canyon, north of that light industrial. That's all commercial.
Correct.
And if you come back down here around Highway 1, then you made some provisions for, other commercial, which would include, churches and residentials and things like that, and other commercial. So you're not, you left visions for that.
Yes.
Mixed use,
so-
which covers all that.
Right, and I was just going to allude to the mixed uses. I've actually, not in Wellington, but in my other communities I've worked in, there's been I'll say a recent trend, which may limit my context a little bit. But a lot of the churches that I worked with in larger communities began looking for sites that were already part of a developed shopping center. They were going in and remodeling existing uses like an old Albertsons or one of them was an old bowling alley. And they were redeveloping those existing commercial land uses for church purposes because of the availability and the readyability of those sites to do just a building permit,
Right.
remodel
Shelf
it
space.
and be ready to go.
They did that in Fort Collins too, Genesis project. Same thing.
Good example for with local context. Mine are not local.
Actually took out an adult entertainment, put a church in. Yeah, that's right.
And so yeah, but then that concept probably goes to support the idea that our mixed use provisions would want to accommodate assembly uses, including religious land uses, to accommodate that need and the availability of that product supply as the town grows. I'll stop sharing for the moment, but I can go back to that at any point if we need to. Was there any other conversation or comments relating to the concept of use limitations? I know that Reese presented a lot in his slideshow presentation on the first third of this meeting. Is everyone generally understanding the concepts behind those use limitations, what they're intended for, how they're applied? We've begun drafting some kind of general recommendations for these various categories and what those separation buffers, landscape and screening buffers might look like. And we're going back and reviewing those before we present the draft. But is everyone kind of the same understanding that that's a best practice that we're going to recommend, and then we can kind of whittle it down on what our specific requirements might look like for Wellington?
I thought it was a great presentation and a great example. So yeah, I would support using that as a model going forward.
Questions or thoughts on the parking concepts that were presented? Parking is definitely a facet of use limitations. And it's going to be defined. We still need to put some pen to paper to come up with recommendations, but any initial thoughts or guidance on the parking concepts that were presented?
Well, I think certainly getting a look at what's comparable to other communities may, again, I'm not sure where ours came from, national standards, are they appropriate? But I think looking at what other communities do, again, we don't want to, it doesn't make sense, as they mentioned, to require someone to have as much parking space as interior space. And obviously you don't want to have a congestion issue because that doesn't help anybody. But I think, all those concepts and best practices are, and we've discussed shared parking and, things like that. So, and I think we've always used the term minimums, but I would absolutely, I think we've got to the point where having a more nuanced conversation might be, we need more parking or we don't need more parking, or where are we going to get the parking? So, I mean, again, are the standards correct? I think it's worth looking at.
I agree with that.
I liked what it said about the parking One space is 200 square feet. That's 10 feet by 20 feet. And I was thinking about a full-size pickup truck, super cab, something like that. Because we're rural, agricultural. Our ranchers and farmers and the guys with the industrial stuff at Cameron, they're driving big trucks. And it's not uncommon at the auto parts store to have somebody pull in with their big truck and a 50-foot gooseneck trailer behind them, and they take up 5 parking spaces at the same time. My truck isn't quite that big, but if I opened up both the front doors, it's going to take up 13, 14 feet, or it's going to smash into the car next to it. Or if it's too small, then the car next to my truck smashes into it, and it dings them all up. And so, our spaces of 200 square feet, although not adequate in every situation, they're pretty good right now. Because when they park on Cleveland to go to the restaurants, you're going to have those big pickup trucks there. They've got to park somewhere.
It's an issue.
Parking is an issue everywhere I've worked. Every community faces it. I thought that one of the points that Reese made with right sizing your parking requirements makes a lot of sense, and is certainly a consideration for Wellington's downtown. I've joked about it in the past that our downtown doesn't have a parking problem. We have a walking problem. That we're not willing to walk a little bit, or we live 3 blocks away and we'll park 2 blocks away and walk the rest of it. And I've been guilty of that myself with young kids. Sometimes you make that decision. And so I do make a little bit light of it, but I think that the downtown in particular warrants a reduction in the off-street parking requirements. And the town it's contemplated in our comprehensive plan that we should continue to look for alternatives to provide on-street parking, to reconfigure lanes, to maximize the availability of on-street parking facilities for general use public spaces, and not require a tremendous amount of off-street parking, because that is a detriment to development and redevelopment. If going back to Reese's table in the example, if a parking space is so many square feet and you require so many parking spaces, suddenly your downtown business is required to provide 3 times as much parking space as building space. And we don't want that to be so detrimental that we can't allow our downtown to develop or redevelop as it sees fit. So we want to continue to look at that and look for other alternatives, but right sizing the requirement so it's fair and equitable for any new business, any existing business is the right thing to do. I feel like we're waning as we drag on here. So any other closing comments or thoughts, and then I'll be happy to take the guidance we've received tonight back and work with Reese and Mark and Logan Simpson to continue to refine these, and we'll start rolling out some more information, and you'll get your reading assignments to you.
You guys have a lot more work to do.
I have a question or an ask, I guess. Going back a few months ago on format. I love everything, we get this. I really struggle to read this green. It's a very light green. Does anybody else have a hard time with that in this,
What? It was green?
these light green, this? And yeah, so I was just gonna ask, can we make that really a dark green? And then maybe even have it in a actual Excel sheet, maybe a non-editable sheet, just so, because I have a hard time tracking back up to the screen and go, oh wait, what was that? What was, so you lose we lose our headers because it's in a PDF format. So yeah, so, and even printing it out, I had it like, I still really can't see that green.
Fit on 8.5 by 11.
So,
Say, we'll, let us take a look at that and we'll see what we can
maybe
provide.
legal would be fine. Ledger.
Yeah, we can look at some different formatting options to make it a little more user friendly.
Yeah, yeah.
And we do know there's a lot of information being compressed into a table. It won't stay in this format for the code. This is more for review purposes, but
I
I'm
know our
also
working
happy.
document, because we're gonna keep
Yeah.
looking at this, and I'm like, okay, this P is where? So
Yeah,
that was
So-
that's just an ask going
Absolutely.
forward, make it a little easier to kind of scroll through and find things.
Absolutely. And I think that's a great comment. So we're going to take a look at some options. I'll throw two things out there. First of all, regarding the colors, we're probably going to start eliminating the colors on this, or at least limiting the number of time, because we've talked about most of these in some general sense. The color coding was primarily to kind of identify at the November meeting what was kind of mostly ready, not ready, or this is going to be a future conversation topic. Now that we've had a lot of those conversations, we'll probably simplify the color coding. And the second comment that our staff is happy to do because of the amount of information here, if we can provide hard copies for any of the commissioners on 11:17, the larger format for your review and ease of reading, we're happy to do that. Just email me, let me know. If you want a hard copy, we'll print it on a larger sheet so you can go through and make your notes on it.
Then we start rattling like Troy.
You know, I'll keep it to 11 by, I'll keep it to 11:17.
I could copy that way.
We still get thrown on that worship thing down there at the bottom. We gotta deal with that.
We're both looking at it going, worship. Worship's all the way down here.
Point well taken. And Mayor, I had a planning commission that used to, every one of them, a 10 person commission requested the full size site plan sheets, 24 by 36 inch. And half of them would sit there at the meeting, flipping pages with the microphone. And it was like, guys, it's on the screen.
Yeah, and religious services is under R, but it's tagged churches.
Maybe a cross reference. We'll check that as well too.
It's fine.
You got me again. Otherwise, I think we're heading down the right path.
I agree.
I think we're heading down the right path. I really do.
What would you like to see done before January? If you had, knowing that it's the holidays and this is probably not going to get as much attention maybe as other month-long breaks that we've had. If streamline and structure our homework for us, what would you like to see accomplished before the January meeting?
So great question, Commissioner Sarter. My ask would be if the commissioners could really take a close look at the use table. If we've identified zone districts and permitted conditional use or a blank, and blanks largely mean not permitted. If you could focus on the land use table, and I can provide larger copies if you'd like them, go through those and really identify what questions do you have? Is this use right for this district? Cross-reference the definitions. Have we adequately captured what the intent of the community is for these uses and where they would be applied? That would be my ask. Great question, or great point on the holidays. I was going to probably within the next week or two start sending out a big chunk of reading assignments just in time for the holidays. So I'll reconsider that and think about if there's a way to roll that out a little gentler, a little more gently than what we had originally anticipated. So I'll put some thought into that. But that'd be my two asks, is the land use code, and then we'll probably start sending the actual draft text that we've been working on.
Sounds good.
Cool. Thanks, everybody.
Thank you.
Good job on the food.
Yeah, the food was awesome.
Thanks for the food.
Melissa, good about.